edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. That's right. We never know when the thought police are going to take down this channel. How's it going, Jody Shiloh? How's it going? The Bill of Rights. Arr, I got motivated right now checking that out. So, as you guys know, I blew my back out pretty bad. So I've been AWOL from these shows. I used to try to go live at least every night, like at least 6 days a week. And now it's like every other day, or if that. And it's been kind of rough. I went from 1 million views a month to about 80,000 views a month. So that tells you it's all about going live and captivating your audience. But I have all these guys blowing up my phone saying, look, dude, even though you're not licensed in Arizona, talk about what's going on with Lane Meers. And so I'm going to talk about Lane Meers. So as you guys know, and I want you to make corrections with me. What's up, 2AJ? I want you to make corrections for me if I get it wrong, okay? Because I have no skin in this game, okay? Other than just being a patriot and loving my country and being a pro First Amendment advocate. My understanding is there was some kind of a problem between Lane Meers and an Arizona city attorney. And again, I'm only licensed to practice law in California and Texas. So I don't know like all the details, and I don't profess to. But what I do know is that Lane, I guess, had a run-in with a Arizona city attorney, and he reached out to the wife of the city attorney, who is also a public servant. It's amazing how all the public servants end up getting with each other, right? Like got a public official here, all tax funded, right? And they all end up getting with each other. A buddy of mine married this ex-IRS agent, and that was the end of our relationship, unfortunately. Into all this weird, like, tarot card crap. And I was like, man, I'm done. We're done, dude. This isn't going to work. Obviously a Democrat, of course. So obviously that wasn't going to work for a card-carrying libertarian who believes in liberty and freedom and less government, right? That's never going to work. So anyways, hey, Steve Conkler, good seeing you, man. So there was some kind of a problem between Lane and the city attorney. I guess Lane was being prosecuted. I don't know all the details. You can put the details in the sidebar. And as a result, and by the way, Lane is a private citizen who has some kind of a news media publication, and he's very outspoken. It kind of reminds me of how people used to be before the freaking school system just went sideways on us, and now they're trying to copy the Germans and the British, right? Where you can literally get thrown in jail for insulting these scumbags that they illegally imported into their country, right? It's crazy. Blows my mind. What's going on, Grateful Dabs? Good seeing you. Hey, Life Under, good seeing you, brother. Oh, that's cool. Put the press the closed captions, dude. You can just listen. Jody Shiloh. Oh! Good seeing you, ma'am. That's cool. We got a couple people. Hey, the bourbon whiskey. That sounds pretty amazing right now. Not to my kidney or liver, but it sounds amazing to me at 19. So anyways, apparently there was some kind of a problem between Lane and the city attorney. And Lane reached out. Oh my God, Grateful Dabs. That was very kind of you. Everybody give me a bunch of ones for Grateful Dabs. I was telling Grateful Dabs, if you guys got to understand is that I also have a wife and a family, and I run a law firm, and I do freelance work to make extra money. And so going live is a real sacrifice for my family, because I know there's no lawyers out there who really are patriots like me. And I know I get so many emails and text messages from you guys. I feel guilty. So I bought a standing desk because I can't sit down anymore because my whole right leg, it's like lights on fire. And I'm doing my best to go live as much as I can, guys. But just keep in mind that, I got a family to feed and support. And so like I'm working overtime and double time to be able to do these shows. So anything you can do to help support the channel means a lot to me. even if it's $1.99. That's what I was trying to tell Dabs. Like, I'm not looking to, I'm not like Chili where you guys are going to send me $500 or whatever. That's fine. But like, even if it's $1.99, just something. So I can say, yeah, I made $1.99 today going live for an hour and a half or 2 hours, Anyways, I digress. So I guess what happened was, and this is a public service, go to his channel to find out all the details. Unfortunately, he does these like hour, 2, 3 hour videos. So it's really, really hard for me to like cover everything. So I'm going to try to compress everything based on my memory, which isn't that good anymore, into something where, what would I do if I was defending Lane Meers in my jurisdiction? Okay, so again, Lane had some kind of an issue with the city attorney. And I think city attorneys, at least in LA, in California, and in Texas, most city attorneys can only prosecute misdemeanors. That's usually a crime that's like up to a certain dollar amount or 6 months or less in jail, right? And then a felony would be a higher crime, and that would be a lot longer. You'd be doing much more time in jail. Oh my God, thanks, Steve. I appreciate that, man. Guys, make sure to like and subscribe to Steve Conkler's channel. He just donated $20. Look, I spent my whole wad for this month in donations over at it's like $150 to this is a public service, because I think he deserves support. And I was trying to tell you guys, look, don't you don't have to send him $150, but send the dude $1.99. If all of the people, if the 200 people in his chat sent him $1.99 a piece, he would be able to like cover a lot of his time and overhead and research that he has to do to help his friend Lane. And I'm not saying that you have to do anything. I'm just saying if you can do it, a dollar is not that much. So that's all I was trying to say. But I really appreciate it, Steve. That was very kind of you. Thank you, Grateful Dabs. Thank you, Mike Wilbur. And never apologize to me because I'm here because by God's grace that I'm alive and I'm able to share the things that I've learned with you from being a lawyer with over 20 years in practice and a patriot who loves my country more than life itself. Because without America, I would have never been able to achieve such greatness. I have no undergrad. I didn't even have a law degree when I became a practicing lawyer. I passed the California State Bar on the law study program, and I became a very, very successful attorney. And when Gavin Newsom and all of his big pharma friends destroyed our economy over something that had a 99.99% survival rate, so they could sell this thing that a lot of people, a lot of experts say is dangerous and harmful, but you can't even mention it because they have that much they have that much monetary prowess. If you say anything bad about what they did on YouTube, you'll have your account banned or you get a strike against you. Think about that. Pretty scary, right? So as a result, all that did was steel me even more to want to like help people like Lane. And I don't have any skin in the game with Lane. I was following him, and I think the guy is very intelligent. There's a lot of things about Lane that I would do differently. As far from a civility point of view, because, I think you can defend yourself better when you're out of jail. But look, I had guys like him in my unit when I was in the Marines. I knew a couple machine gunners that were like him. And so I recognize we're not all the same, but I don't think that judges and people who are products of the educational industrial complex that was imported here from Prussia years ago by the Rockefeller family understand that. I think that most of our college system is basically a microcosm, a model of what's going on in Europe, where they have the crime of insult. If you say something bad about someone, you feel harassed, you feel insulted. Oh my God, it's the end of the world, right? But that's not what our founding fathers wanted. Our founding fathers wanted max free speech. And if you feel offended or whatever, go F yourself, because that's your problem, not mine. I'm not going to be held criminally accountable because you feel offended, right? Give me a bunch of ones if you guys agree. So, yeah, a whole generation lost on educational policies. That's right, Beyond Watcher. Absolutely. What a joke. What a freaking disgrace, man. But anyways, I don't want to digress too far. So anyways, My understanding, and you can correct me if I'm wrong in the sidebar, is that after some time, Lane, for whatever reason, contacted this law professor who happens at the University of Arizona, and correct me if I'm wrong about that, but I'm pretty sure it was University of Arizona. So that would make her a public official. That would make her a state actor, as far as I'm concerned, is a federal civil rights attorney. And he reached out to her, and within days, his wife was fired from her job. And apparently, she had worked for a federal judge, not state, but federal. And as a result of Lane contacting this woman and leaving one voicemail, as far as I understand, it was one, not multiple, not males plural, but one voicemail. His wife was terminated from her job working for this federal judge. So obviously that hurt Lane's family. And so Lane started doing YouTube videos about this woman called Shannon Walker. And again, correct me if I'm wrong. And if you're a judge, or if you're Shannon Walker, or if you're her husband, reach out to me and tell me your side of the story, because I'm not looking to try and score points with anyone. What I'm trying to do is lay down the law from my perspective as a natural law advocate, which means that our rights come from an all-powerful creator, according to the Declaration of Independence. Unfortunately, college professors don't believe that. In fact, I've never met a conservative or a libertarian law professor. Most of them are far left Marxists. In fact, most government employees that I've met are far left, hardcore lefty Democrats. They hate the Second Amendment, and they hate people like Lane. They hate Marines. They don't like people like me. So naturally, they haven't enamored themselves with me in any way, shape, or form. So my understand. So that, just so you understand, like, I don't believe. I believe that our founding fathers, the reason the First Amendment was so important is because they wanted to hold government officials accountable. And unfortunately, our educational industrial complex has created a bunch of weaklings. You go on to any college, and they have safe spaces. They're anti-white male. They have this thing called diversity, equity, and inclusion, which is basically just code for I hate white people. That's all it really means. And I think most people have caught on to that. And that's why Trump won in overwhelming numbers. And who knows if he's going to make any real difference. But he won because he ran on that. These are the people that want men to be able to compete in women's sports. I mean, are you kidding me? A dude competing in women's sports? They put tampon machines in women's restrooms. I mean, obviously, a guy like me, and 99% of any male that you meet who has testosterone level that's even above an ant isn't going to support that. It's ridiculous. It lacks any and all shape or form of common sense. But these people are entrenched in the educational industrial complex. And so when they run across a guy like Lane, who's really loud, obnoxious, doesn't abide by their standard, their objective standard of what harassment might mean, then we have a problem, right? They're going to try to lock him up because to them, he's a crazy person, right? So that's just the reality. All right. So give me a bunch of ones if you guys agree. That's the reality. So let me see here. I'm just looking at the comments in the sidebar. We got Torque Auditor. Hey, Torque Auditor, it's a felony to say Shannon Walker on a YouTube live stream about Lane Meers' case. Well, I don't know that to be true. Torque Auditor, no one's ever served me with any document saying I couldn't mention someone who's in a legal case with this woman named Shannon Walker. And I'm not here to try to attack this woman or her husband. I'm trying to lay down the facts. So hopefully they don't try to arrest me or something. And I'm not sitting here trying to claim that I'm like some legal genius. But my understanding of the case is that once Lane's wife got fired, that basically was like a declaration of war on Lane. And Lane is not a lawyer. And obviously he doesn't understand basic civility. If he did, he probably wouldn't be in jail. And I've tried to tell other people that as well. But it's just not the way he rolls. But me as a lawyer, and having done so much criminal defense work, and also having had worked for the prosecutor's office in Los Angeles, which is also a very far left-wing organization, probably like what's my understanding is most of the Arizona lawyers and judges are imported from California. So it makes sense, right? Because you have these people in Arizona who are used to being able to open carry and say what they want. Typical old school Americans, like who abide by the old code. Now their whole judiciary, administrative state, outsiders from New York City, New York, right? Pace pecani sauce, have taken over all the bureaucracy. And so guys like Lane are looked at as like a crazy person. But the old school judges who are from the actual community who grew up there would not have treated Lane in this way. That's what a lot of people are telling me. So I'm getting, my cell phone's blowing up constantly. Please cover this. Please cover this. How would you handle this? So all I can do is say how I would handle this if I was a lawyer in Texas or California, because I'm not licensed to practice law in Arizona. But, the upside is I can still talk about federal law and how I would handle this is a federal case, right? If I was going to try to defend this federally. And I keep telling everyone, I don't think he has a chance unless he goes up on a habeas. I really do believe that the definition of harassment and who gets to decide what objective harassment is basically means he's screwed. And so I'm going to get into how I would challenge this case on its face to try to get a reversal, because in my opinion, he's already been convicted. I don't believe that he's going to win based upon the way the statute's written and based upon the way he's been treated so far. I just don't see that there's going to be a fair trial. I think at voir dire, what they'll do is, so here's another problem with voir dire. With voir dire, where they impanel the jury, typically the people who get impaneled are bureaucrats, people who are able to afford to be on the jury. Only government employees get paid to be on a jury, as far as I know. I mean, tell me if I'm wrong. But I would say 99% of government employees are hardcore Democrats. And Lane Meers, on all of his shows, is wearing a MAGA, Make America Great Again hat. Do you really think that a jury that works for the IRS is going to find in favor of a guy like Lane Meers? I'm just asking you. I'm not making any statements one way or another. But what do you think? Do you think that a Democrat would ever... We see what they're doing right now, like blowing up Teslas and, whatever George Soros tells them to do, they're doing, right? So, and I'm a libertarian, so I don't have skin in the game. I am a pro Second Amendment, pro First Amendment, inactive United States Marine. I believe in the original Bill of Rights, not the one that's being diluted by the educational industrial complex and, in my opinion, law schools. I became a lawyer with no law degree or undergrad, but I was admitted into a law school, and they waived my first year courses because I'd already passed the baby bar. And I would say, without a question, all of my law professors were radical leftists. And it's just it's almost like you can't even get a job as a teacher or a law professor unless you're like an Obama supporter, right? That was what I noticed. And so, like, if you're a white male, forget about it. You're the enemy, as far as I'm concerned. That's how they think. So I have a lot of issues with what's going on with Lane Meers. And so because of what I know about how the bureaucracy works, I know about government employees, I know that the jury, it's going to be very difficult. And look, if Lane keeps on popping off, right, and scares away even his potential defense lawyer. And so far, I'm not that impressed with any of the defense lawyers that he's had. He's going to end up representing himself. And because Lane doesn't have the experience of trying cases and arguing cases before a judge, Lane makes a lot of conclusory statements and conclusory allegations. And that can only serve to hurt him. And he also makes a lot of statements that are, like what many judges and defense attorneys, and especially jurors, especially if they're government employees, would consider to be obnoxious and unreasonable. So let me just share something with you. When I took my first CCW course, a buddy of mine who was a MARSOC Marine taught me that the best way to get convicted for murder, even if it's in self-defense, is if you draw down on someone who's attacking you and start swearing at them, cussing and swearing loud. Because 99% of the people in this world have been programmed by the administrative state to think that the guy who's loud and obnoxious and cussing was at fault. That's just the way it is, guys. That's just the way it is. And give me a bunch of ones if you disagree. Give me a bunch of twos if you agree that the one who comes off as loud and obnoxious always is considered to be the initial aggressor by most people, because most people are very judgmental and they haven't been brought up the way that I have by a bunch of freaking savages in the military Marine Corps lifestyle. My dad was a crazy Marine. All of his friends were crazy Vietnam veterans. Totally different mentality. Speaking your mind was normal to me. My dad told me, be defined in all things that you do. Even at the risk of losing clients, I do these shows because I am defined. People know who Mike Ehline is. I'm not going to beat around the bushes to try to get money from you or to try to get you to hire me. I'm not going to beat around the bushes to try to keep you as a client. If you don't like who I am, then hire someone else. I'm defined. I am who I am, like Popeye said. I'm a patriot and I love America. Okay, so let's get back into the gist and the basis of this conversation. So Lane Meers isn't one of those people either. He reminds me of me in many ways. The difference is I've been tempered by over 20 years in practice as a lawyer, and I've learned that you have to play the game to a degree in order to win, because most people aren't like me. Most people aren't like Lane, and they won't understand us. It takes a very compassionate and understanding individual to understand people like us. Unfortunately, it didn't used to be that way. We used to be the majority. But after all these years, 60, 70 years since whenever Jimmy Carter created the Department of Education and destroyed our education system, we just have a bunch of weaklings now, basically being churned out by the public schools, right? The rainbow flag mafia, many people say, right? So let me just look over into the sidebar here. That's right. Thank you, brother. And look, Pro Se America, I got completely chastised for helping Chile de Castro. I had people go into my law office, people writing letters to a landlord, trying to throw me under the bus. I couldn't believe it, all because I was trying to defend Chile when he was unlawfully incarcerated. And I went and visited him in jail when no one else would. Everyone was scared. And ultimately, people started writing the jail to the point where the jail administrators kicked me out and wouldn't let me visit him anymore. So I just want to tell you, this is what we're dealing with. I believe that this is a satanic, Luciferian cabal. And these people are evil, wicked people. People like Broom Hillary and Barack Obama, these people are wicked individuals and they hate America. And I am their enemy. And according to them, I mean, they even have, when I was younger, I remember when Hussein put out this memo that anyone who served in the military is a potential domestic violent extremist. And the lefties really believe that if you served in the military, if you're a white male, if you believe in the Second Amendment, if you go to church, you're a potential domestic violent extremist. They really believe that. And that's what all the public school teachers teach too, at least in California. So that's what's going on, guys. So that's kind of what happened here. And I believe that Lane is suffering the after effects of that in many ways. So what would I do? What would I do to defend Lane Meers on a federal level if I was in California or Texas? All right. So a lot of people are saying, look, Shannon Walker lied. She lied about, emails when there was, or phone calls or phone calls, I guess, when there was only one phone call, for example. They say that. And, and they're really fixated on, did Lane Meers violate the terms and conditions of his injunction? Did he do all this other stuff? And I just want to focus on the things that I know, as having been an appellate lawyer, having externed for one of the top appellate justices in the United States, Justice Gary Hastings in California. His father was actually I think he was the lead, the author of Kelly versus New West, which is the seminal case on motions in limine. And so whenever I run across a case like this, my my natural inclination to defend the underdog comes out. And especially being a jarhead, because we're the smallest branch, right? So I understand that we got to fight twice as hard, 10 times harder than everyone else to get some respect. And so I see a lot of crazy stuff going on. So I don't want to get into, what Shannon Walker said or did, or what makes her bad, or what makes her husband bad, or the fact that they're both public servants. And likely probably Democrats and stuff like that, because that's not going to help you understand the law, right? And that's all, I'm hearing just all this negative about her and her husband, and the fact that they're all friends with the prosecutors at the county and the judges are all in on it. And I hear all that. Guys, that's not going to help you win anything, right? The way you win, look, you can try recalls, of course. You can try impeachment. But if you don't have political power, you're not going to. And a bunch of crazy people standing around with a bunch of signs saying free Lane Meers is probably going to scare them even more. The way that you win is to win people over, not win over them. And that's something that I'm good at doing as a lawyer, as I understand the concept of winning people over, not winning over them. You can't win over anyone, especially when they're already politically completely opposite to everything that you stand for. So the only thing you have is your personality and the ability to be articulate. Does that make sense? Give me a bunch of ones if you understand. I know that probably half of you guys are going to think, oh, this guy sucks. He's not standing tall for Lane, and he's not a sovereign citizen and all this stuff, and arguing jurisdiction and challenging everyone. But guys, all that's going to do is get you in jail, right? I want to win. I understand that he has a wife and she needs him. And so I'm looking at it as a husband and a father of 2 kids. I spent all my time putting my kids through martial arts training, teaching my wife self-defense as well as my kids. And that's basically my life, supporting the family. As most of you guys know, I don't even do civil rights anymore. I do car accidents, truck accidents. I've got one of the largest motorcycle accident settlements in the history of the United States. And I primarily represent military veterans because I got sick of dealing with people with this woke mentality. And I know that military vets are the only ones that really understand me, and I understand them. And I know that at least some judges, at least in Texas, respect me because Texas still has some patriotic judges, right? Give me a bunch of ones if you agree with that. Because I do agree that Texas does have quite a few like military veteran, patriotic judges. We even found a judge at the Ninth Circuit, Van Dyke, a couple weeks ago, get out there and teach us how to strip down a firearm, and taught us the difference between an accessory and a component, and completely destroyed the en banc Ninth Circuit. A majority decision, right? A bunch of Obama judges, right? You see what happens, right? Obama judges make Obama decisions, many people say. So I would be curious to know, like, who, at the state level, I would almost bet my life that these people have all donated money to Act Blue and they're all pro George Soros, the Obama types, right? So that's where we go with that. So what would I do to defend Lane Meers? Okay, let's forget about Shannon Walker and the fact that she's a public official and that her husband's a prosecutor, that he forwarded charges to a county prosecutor, and that we know that public servants and government employees are pretty much all buddies, according to many. So let's forget about all that and talk about what we would do to try to win this case, because I can already feel like he's going to lose at the state level. So I would automatically, in my mind, be thinking like a chess player, 3 moves ahead, right? 3 moves ahead. I would be thinking, how can I win this case? Because I already know I'm going to lose at the state level. I'm going to get a jury filled with a bunch of lefties because I know that only government employees can afford to be on there. And the smart people always figure out ways to get off the jury, right? Oh, I can't do this. I'm sick. I'm this, I'm that. But the people who can get paid for it, or they got an axe to grind, like, could you imagine all these people like burning up Teslas, how stoked they would be to get on the jury to convict Elon Musk? Think about that. Okay. Now for me, every time I try to get on jury duty and I admit to the judge that I believe in jury nullification, and I've written articles about it, I'm automatically disqualified. I can't even be on a jury, even though John Jay and Thomas Jefferson were proponents of jury nullification. And we can talk about jury nullification another time. So, and it works the exact opposite way. If I was a liar and didn't say that I believed in jury nullification and got on a jury and nullified Lane Meers' sentence, and then one of these people, with the police department or sheriff did some research on me and found out that I support jury nullification, then I could be prosecuted for perjury, perhaps, right? I just want you guys to understand like what's going on in this country right now, because the judge will tell you, do you promise, right, under penalty of perjury, that you will only judge the facts and not the law? Even though our founding father said, no, 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 no. We, the people, have a right to decide the facts and the law. But you tell a judge that, and it's almost, they look at you like you're a crazy person. So just think about that. It's wild to me. It blows me away. But, when you go to when you're educated in a system that teaches you one way, and that's what you're taught to think, and that system also pays your check, it's very difficult for a lot of people to look out. So I'd rather be broke than go against my principles. I guess that's the point that I'm trying to make. All right. So what would I do then? What would I do to challenge an unconstitutional situation that I'm in? And because that's what I believe that Lane's only chance is. Again, at a federal level, if I was in California or Texas. Now, I would always tell Lane and his lawyer or his family, do your own research in Arizona and hire an Arizona attorney, because I can't go beyond where I'm licensed to practice law. But I would challenge the statute on its face as being unconstitutional. Okay? I would challenge the statute that talks about harassment on its face is unconstitutional. I wouldn't even try to argue that she lied and this and that, because let's face it, she's already being favored by the system, irrespective of what you want to believe or think. Based on what I've seen and what I've listened to in the testimony, I think that Lane doesn't have a chance. Okay, I really do believe that. I think that it's almost like the writing is on the wall. So habeas corpus is probably the only option, in my opinion, that he has. And then obviously finding a lawyer like me who's going to go in there and start arguing with the judge and getting all sideways, because they can't handle it. They're not trained to deal with people like Lane, right? If he was a lawyer, he would be disbarred within a few minutes, with the behavior that he exhibits and exudes. And I'm just being honest with you. I mean, I love the guy. I think he's a good guy. I'm more concerned about his family, to be honest, at this point, because they need him. And so, and again, I don't think he did anything wrong. I just think that the system doesn't understand people like Lane, or really me for that matter. It's just that I've learned how to temper myself after 20 years in practice. But I still have that Marine mentality, and I still want to fight for people's rights, people like Lane and his family. So here's how I would do it. I would challenge the statute is vague and ambiguous on its face. I would argue that the law itself is invalid due to its lack of clarity. Okay? Due to its lack of clarity. Okay, so what would I do to defend Lane Meers and get this case reversed on appeal? Because I don't think he's going to win in oral argument. I believe that although he's a legal scholar and he's a jurist to a large degree, most of his arguments are conclusory and they're not fact-based. And because of that, it gives the judge the ability to railroad him if they want to. Conclusory statements are not evidence. Facts are evidence. So he has a hodgepodge of facts and conclusory statements. And so a conclusory statement would be like, well, she lied under oath and therefore this case should be dismissed. No, look, a statement like a factual statement would be something like this. On such and such a date, I left a voicemail. And that is the only time I ever left a voicemail. See Exhibit 1 telephone records. See Exhibit 2, telephone records that I subpoenaed from Shannon Walker that she had to turn over, showing that no phone calls came from me. See Exhibit 3, sworn declaration from me or any witnesses who were with me when I made the call, right? And then the burden would be on her or the prosecutorial team to produce evidence that he made more than one phone call. Are you guys following me so far? I wouldn't just make, oh no, I didn't do it and she's a liar. No, that's not going to win your case. So, okay. So I'm not saying that he's wrong, but I'm saying that conclusory statements don't get you anywhere. It gets you what? $2 gets you a cup of coffee now, or maybe $5 nowadays, 10 maybe if you're in California, get you a cup of coffee, right? But it doesn't win your case. Okay. Give me a bunch of ones if you understand what I'm saying so far, because I'm running the risk of alienating people who are going to say, oh, you're not being pro Lane or whatever. No, dude, I'm trying to help. I'm trying to help you guys understand the law so you don't get yourself in the same pickle. Because a factual based statement is different than a conclusory statement. Conclusory statements don't win your case. So again, a factual based statement on such and such a date, this happened. See Exhibit 1, see Exhibit 2, see Exhibit 3. Phone records that I subpoenaed. I subpoenaed these phone records. I have a right to them, right? See Exhibit 3, declaration of myself under penalty of perjury that I only made one phone call. See Exhibit 4, all of my cell phone records, and the declaration would also allude back to the fact that I've only used this phone call to ever call this telephone to ever call this individual. Are you following me so far? Those are called facts. Those are called facts. And that's what I want you to understand. Again, I'm a lawyer, guys. So this is my world. Okay. You're in my world now. So I just want, yes, that's right, Sir Richard. Just deal in facts. Thanks, Kevin Bernarski. Yeah. Thanks for understanding. Because I want you guys to understand, I'm not looking to put anybody down or any of that kind of stuff. That's not my goal here. My goal is to help. Honestly, I care about his family, because I know that he's the provider and I know his wife loves him. And I'm also a family man, and I don't want this guy locked up. I don't think he deserves to be locked. I don't think he did anything that was physically threatening. And to me, that's what harassment is. To me, harassment is something where you physically threaten someone to the point where they're in fear for their life. If someone's butt hurt or their feelings are hurt, maybe they need to go back to the school of the Americas and learn how to be an American, because we have a First Amendment here. If you don't like the way Lane Meers talks to you, maybe it's you who should move to the United Kingdom or Germany, where they have the crime of insult. But this guy, look, you don't have to answer his phone. You don't have to take his calls. And if some nut job calls you because he did a YouTube video, then block their number. I don't know what else to tell you. But I do understand also as a husband, like if someone was calling my wife and making statements like, we're going to hold you accountable and we hate you or whatever, I'd be alarmed. But guess what, guys? My wife's armed. I'm not really that worried about it. She's a better shot than me now. I mean, I've taken her through so many CQB courses that I really don't. I think that anybody who messed with my wife is really going to be in more danger than her. So I'm not really that, you know what I mean? Because I'm an American. I understand that there's a First and a Second Amendment. So if someone offends my wife with the First Amendment and she feels a little afraid, that she has the Second Amendment to fight back. Unfortunately, most leftists don't understand that. They want to take away your firearms and your ability to defend your family, because they think that the government's going to defend you, even though case law is very clear that the police have zero duty to protect you. And the same people that those people vote for have flooded our country with over 20 million illegal aliens, many of them hardened criminals who are going after our wives and kids. And at the same time, they want to disarm us. They want to make us just like Germany and just like the United Kingdom, victims. And I'm not going to allow that over my dead body, right? So anyways, let's get back into it. Knowledge is power. That's right, Steve. So what would I do? What would I do to defend Lane Meers if this case was in California or Texas? I would make what's called a facial challenge to the statute itself. I would argue that the actual statute is unconstitutional and it's void for vagueness. It's called the void for vagueness doctrine. Okay, so take a look at it. It's called the void for vagueness doctrine. It's under the U.S. Constitution, and there's similar principles in other legal systems, like English common law systems. And so I'm going to give you a step-to-step guide on how Lane Meers could defeat this case constitutionally. Aside from all, don't play their game, like trying to say that Shannon Walker is a liar and all that. That's not making conclusory statements without evidence isn't going to win the case. What's going to win the case is to say that it's the statute itself, this whole thing about harassment is void for vagueness. And I would argue, and obviously based upon the way the judges so far that I've heard in the case, and based upon his problems with the judges, they probably, I would venture to say, don't like Lane very much. And they're probably, if I was a judge with that same background and training, I would probably do everything I could do to lock this guy up. All right. But I'm not. I am a free man upon the land. So I would say that, first of all, you'd want to understand the legal basis for making these arguments. And the void for vagueness doctrine stems from the due process clause of the 5th and 14th Amendments in the U.S. Constitution. A statute can be struck down as unconstitutionally vague if it fails to provide fair notice of what conduct is prohibited or required, leaving people of ordinary intelligence guessing at its meaning, right? So when a judge at a hearing who's allegedly, right, above average intelligence, because they're a judge, and they're saying, I find that I would feel this way, but they're not someone of ordinary intelligence, and that's why he'll lose in the preliminary phase, because judges are of above average intelligence. That's why I always have a problem with judges deciding like preliminary injunctions and things like that, because these are people with law school training and mainly from very far left universities. I've only met 2 or 3 judges in my life that were conservatives. I would say the vast majority of them are hardcore lefties. And so that means they come from a school system where they have safe spaces, right? Where they have DEI and, especially if they're young ones, right? DEI, anti-white. It's impossible for minorities to be racist. White people are evil. And that's kind of like what they teach on these college campuses. And that spreads itself into the universities. And so, and the law schools. It's unbelievable. You drive into any university, look in the teacher's parking lot, the professor's parking, look at their bumper stickers. I mean, it's crazy. Just take a look sometime, guys. It'll blow your mind. Che Guevara. It's like, are you kidding me? Che Guevara hated black people. And here you have is because they just believe anything that, the left tells them. So anyways, I would say that it fails to provide fair notice of what conduct is prohibited or required, leaving people of ordinary intelligence guessing at its meaning. All right. And so that's the word is going to be harassment. Remember this. Give me a bunch of ones. Harassment. Harassment is what we're talking about. What is harassment? Think about it. What is harassment? And then you would argue as a second element would be it invites arbitrary or discriminatory enforcement by giving law enforcement, prosecutors, or judges excessive discretion. So for a facial challenge, you would want to show that the statute is vague in all its applications, meaning no set of circumstances exists under which it could ever be valid. Now, it is a high bar under United States versus Salerno. United States versus Salerno. It's a 1987 case. Salerno. Okay. However, in First Amendment cases like this is a pure First Amendment case. If I was going to be arguing this in California or Texas, I would argue this is a pure First Amendment case. Courts can sometimes apply a lower threshold, and they can strike down laws if they're vague in a substantial number of applications. And that's NAACP versus Button. NAACP versus Button. Button. Type it in the sidebar for everyone else. Button. It's a 1963 case. I shepherdized it. It's still a valid case. All right. The next thing, part 2 of your analysis would be identify what's vague about the statute. Okay. So hopefully you guys are following me so far. What's vague? Hey, Brandy, how are you, ma'am? And that might be true, Edward Potts, but I'm not here to argue why it all started or how it started or if Shannon Walker is a liar or if her husband and her are involved in some conspiracy because they're government employees or any of that kind of stuff. I'm here to argue because I do believe that Lane is probably going to be convicted, and his only chance, unless he files a writ and makes these arguments now and preempts a trial, is the arguments that I'm making. Okay, I'm just being honest with you, and I'm a positive guy. I'm a positive thinker, but I'm not licensed in Arizona, unfortunately. Otherwise, I would be representing him pro bono because I believe that this is so far what I've seen, in my opinion, has been a miscarriage of justice against Lane Meers and his family. I believe that if this was in California or Texas, that I would be able to defeat this. I have a high belief, a high opinion of my legal skills that I would be able to defeat this case. But I believe that so far, his attorney and him, to a lesser degree, him, are not seeing the forest through the trees. And that's why I'm trying to explain how I think he could win. Give me a bunch of ones, at least if you guys respect the fact that I'm trying to give you a different point of view. All right. I mean, because I'm doing this at great risk to myself. I'll probably lose a bunch of subscribers because a lot of people are just like, Lane's God. He's this, he's that. And look, he's a great guy, whatever. But I want him to win. I don't really care about all this other stuff, right? Like I am a tactician, and at a tactical level, I want him to be able to win. I understand the strategy, guys. I get it. But tactics are what matter right now, not the strategy. The strategy is to win. The tactics are how do you win? All right. So number 2 is you want to identify the statute's vagueness. And here you want to ask yourself, are the key terms undefined or overly broad? Are the key terms undefined or overly broad? For example, annoying, unreasonable, immoral. What the hell does that mean? Because to someone in San Francisco, or someone like like Obama or somebody who went to Epstein Island, right, on a regular basis, immoral might mean something totally different than someone who lives in Texas or an original resident of Arizona who's like an old schooler, not from California, not a California transplant, right? What does immoral mean? Well, to me, being an old school Marine, I think a man competing in female sports is immoral. I think it's unreasonable, and I think it's annoying. But to someone from San Francisco who might now be a judge in Arizona or a juror, to them, that's awesome. That's amazing, right? So because of that, those, without further defining those terms, they're basically undefined or overly broad. That's what I would argue. Does it lack clear standards for compliance or enforcement? Well, I kind of think it does here. Give me some comments in the sidebar what you think. Could it sweep in protected conduct? For example, free speech or freedom of association. I mean, already we're listening to voicemails from people who are calling Shannon Walker and leaving her some pretty rude and abusive emails and voicemails, right? Both saying they want to hold her accountable. It kind of sounds threatening to me. I'd be scared, but not really, because I would return fire. But you know what I mean? Like, to me, it's like, whatever, come at me, bro. But yeah, could it sweep in protected conduct due to its ambiguity? And in this case, absolutely. Free speech, association. I mean, when a judge says, I'm satisfied that all these voicemails that I heard are because of Lane Meers, to me, it's like, don't they realize that direct meth and all these other people that are out there who hate Lane Meers could be the ones making these phone calls? That's the problem that I have too, is there's literally people out there that want to see Lane Meers get locked up. It could even be a rogue cop leaving these voice messages. So it lacks foundation, right? Lacks any kind of foundation that any of these messages came from anybody who are associated with Lane Meers. So I would definitely argue that it sweeps in protected conduct like free speech and association due to its ambiguity, in enforcement especially. So, for example, in Papa Christou, PAPACHRISTOU versus City of Jacksonville, Papa Christou versus City of Jacksonville, it's a 1972 case. A vagrancy ordinance was struck down as vague because terms like wandering and loitering didn't clarify what was illegal, and risking arbitrary policing. And that's what I feel is happening here. I think it's arbitrary policing. In my opinion, if this was California or Texas, so California has a little bit different. So California, in a lot of the restraining order cases that I've done, it requires a clear and present intent to do bodily harm, not your feelings, right? The feelings police aren't involved, and which is striking to me because I always thought Arizona was like more like tough people, but California still has holdover laws from when the Republicans ran the state, where they actually understood the Bill of Rights and the Constitution, at least with respect to the First Amendment. So, like someone feeling like they were harassed is not something that comes into play. It's whether or not there's a clear and present intent to cause someone bodily injury. And I don't see that here at all. So to me, it's unbelievable. It reminds me of like something in Germany or the United Kingdom. I'm trying to understand how a statute like this even got passed, to be honest with you. But the next thing you have to do is choose the right forum. Well, unfortunately, the only way that Lane is going to be able to choose the right forum is to try to get it removed to federal court, right? Or get it removed to a different jurisdiction. But the problem is with state courts, especially in like these podunk towns, many people say Arizona is still kind of a podunk state, that all the cops, state police, city police, sheriffs are all buddies, and they're the ones who have the ear of the judge, right? So who runs the judge's court? Usually it's going to be a bailiff or a sheriff, right? And they're usually buddies with the judge. I know because I used to work for a judge. So if the sheriff or the deputy, they're going golfing with the judge and they're having Christmas dinners with them and they're friends with these other cops who are friends with the prosecutor, it really, really makes it hard from the perspective of a defendant to feel like he's getting a fair trial, right? Do you guys agree with that or not? I mean, I just want to know what your opinion is. I just want to know what you guys think. Now, Luke says that he worried the woman and her children, and she had to take affirmative steps. How can you defend it? He should have stopped immediately, but he did not. Well, Luke, I would like to see that evidence because what I see is something different. I see someone who exercised their First Amendment rights. I never heard a threat, and this was a public official, which we'll get into in a little while because I know a lot of people are saying this was not a public servant, right? Again, I'm arguing this from the perspective of a defense attorney, not from the perspective of a prosecutor. And my clients I'm not saying that he's my client, but hypothetically, if he was my client, he's entitled to 100% of me, not a hedging person who's going to hedge. And that's just not how it works. So I'm arguing if I was defending Lane, how would I defend him? All right. So here's what I would do. I would. Okay. So hold on one second. Let me get back into it. So I would argue, and alive, I'm already. All right. So the next thing I would want to choose the right forum. All right. So if it's a criminal case and you're charged under the statute, raise the vagueness challenge as a defense in court. So far, I have not seen that challenge being raised. And that's the first thing that I would have raised if I was Lane Meers. And I understand that he has this natural reaction to want to argue against, oh, well, you're saying I violated this, that I did this thing. I didn't do this thing. But for me, because my background is judo, I would use the inertia of being thrown against me and throw my opponent the other direction by simply arguing, so what? I would demur. Do you guys understand what a demur is? Basically, it means what? What? I would demur. I would basically say, look, it's vague. It's ambiguous. I don't understand. I don't understand the nature and the cause of the charges against me because on its face, The law itself is unconstitutional. Are you guys starting to understand? So that's the first thing that I would argue. Now, if it's a civil action, I would say that I would file a preemptive lawsuit, and I would file what's called a motion for declaratory relief. And this is something we can talk about in another show. And again, guys, look, I do personal injury law for a living now. I do police shooting and tight handcuff cases, some elder abuse, but my true love is civil rights. Unfortunately, I just was never able to. I was spending all my own money to fund cases like Lane's because most of my clients didn't have money. And then I would go in and try to argue for attorney's fees, get undercut every single time by the judge. And I just got tired of doing it, because it's like I can't support a wife and kids when I'm constantly having my fees reduced and being forced to eat my costs, right? It's very, very difficult. Whether you want to believe it's by design or not, that's up to you. But at least I can, a guy like Lane, if he was armed with this knowledge, I think that he could kick some serious butt. Give me a bunch of ones if you agree. So timing matters. You generally need standing, a concrete injury or credible threat of enforcement to sue. And in this case, he's already incarcerated. So he's definitely got standing. I mean, in his case, if he was to file a civil rights lawsuit after he wins this case, he would be in a strong position but for the fact that judges are pretty much have sovereign immunity, and pretty much prosecutors do too. So it's really, really difficult to sue someone for malicious prosecution if they're a prosecutor. It's unbelievable. Like the cards are stacked against them from the start. And that's why I always tell you guys that you need to always approach this with civility and stop trying to win over people, try to win them over. Because ultimately the people that are going to be hearing your case are people who aren't like you. And that's just the problem. Most judges are not conservatives, in my opinion. And most of them are very far left because they grew up in that system. And if someone can prove me wrong, I'd love to hear it. But that's what you're going to be dealing with. Right. I saw that, Beyond Watchers. Right. So you got to build your argument. So step 4, build your argument. Legal precedent like Grained versus City of Rockford, 1972. The statute has to give fair warning. Or Kolender, Kolender versus Lawson, a 1983 case. The statute must establish minimum guidelines for enforcement. All right. And there has to be a textual analysis. You have to highlight the ambiguous language in the hypothetical scenarios showing inconsistent application. There's a constitutional hook. You need to tie vagueness to a protected right. First Amendment speech, 5th, 14th Amendment, due process, right? You're entitled to notice and opportunity in order to protect yourself against and defend yourself against the charges. How can you have notice when you don't even understand the nature and the cause of the action? Oh, I would feel harassed. Well, that's a feeling. You feel an objective, reasonable. What do you mean objective, reasonable person? You mean someone from San Francisco or from Germany, or someone from the local community who doesn't give a shit about your feelings, right? See what I mean? To me, this statute, this harassment statute, should be challenged. That's the way I feel. Facial versus as applied would be the next argument. For a facial challenge, you would want to argue the statute's flaws are pervasive, not just problematic in your case. I mean, they're so pervasive, there's no way that you're ever going to be able to win this case, and you still don't even understand what the hell does harassment mean. Okay, so the next thing you'd want to do is file a motion or a complaint. In a criminal case, you'd want to file a motion to dismiss. In California, I think it's 1538.5. No, wait. Oh, gosh, I forgot. But a motion to suppress 50. I'll remember it in a minute. It's been a while, guys. Gosh, I feel like a retard. In a civil case, you'd want to draft a complaint seeking an injunction or declaratory relief, which I said before. But the idea is you want to file a motion to dismiss, right? Because it's vague on its face, right? It's as applied. It's just factual versus as applied. You don't understand it. You don't understand the nature and the cause of the action. You're not being given adequate notice and opportunity to be able to defend against the charge. You got to learn how to navigate the courts. Lower courts, you're going to present the evidence and argument. You're going to probably want to bring in an expert. They're very expensive. And you're going to argue that the statute's unclear terms and real-world examples lead to erratic enforcement. And here, obviously, it's erratic enforcement. I mean, come on. I think most people believe that the only reason they're charging him with this stuff is because he comes off like a crazy person, right? And then you want to file your appeal or file a writ, like peremptory, right? File that writ of mandate, writ of habeas corpus, writ of prohibition, prohibiting them from enforcing the vague and ambiguous law. Are you guys understanding so far? Give me a bunch of ones if you're understanding so far, because I need to know that I'm not just talking out my rear end. Well, thank you, Kirsna. I appreciate you saying that. That was very kind of you. Ringo, it takes a lot more than ruled against me to prove impartiality of a judge. And Luke, I can see that you're pro government, and that's fine. But go do that at your college campus and go hide under a chair somewhere, right? I'm here to talk to the real Americans who believe in individual rights and liberty, people who believe in the right of open carry, people who believe in constitutional carry, people who believe that our borders should be secure and that men shouldn't be competing in women's sports. And so far, based upon what I've heard from you, it sounds like you're one of those people, those other people. So I'm talking to the other ones that are more like me, right? So practical tips. Allies, you want to seek support from civil liberties groups. Unfortunately, the ACLU is totally, in my opinion, bought and paid for by guys like George Soros. In my opinion, there was a radical shift. All right. So I used to be a Democrat. So I believed, I supported hippies. Democrats were anti-war, right? They didn't support war under any conditions. And now the Democrats have completely flipped. They're the party of war to the point where they're willing to risk a nuclear war with Russia after the Ukraine and these European countries violated the agreement between Russia to allow Ukraine to have its independence, that under no circumstances would Ukraine ever become part of the United Nations because Russia feels threatened, right? So I come from that original Democrat party that supported that concept, right? But now the Democrats are all the military industrial complex, the bankers, George Soros, right? Bill Gates, all Democrats, right? So it's like did a judo move. So unfortunately, I had to leave the Democrat Party. And of course, the Democrats never supported genital mutilation of children. Like they were pro-family. They didn't burn American flags when I was a Democrat, right? But now good luck finding an American flag at any Democrat politician rally, right? So unbelievable. So anyways, back to the practical tips. Seek allies. Unfortunately, the ACLU probably isn't going to work because they don't support people like Lane, right? Public pressure. Public pressure is important. Highlight the state's absurdity or overreach in public discourse. This won't directly sway a court, of course. Narrowing construction. Be prepared for courts to interpret the statute narrowly to save it. Argue why this isn't possible, right? So the court is going to try to narrowly interpret the statute, the harassment statute, to try and save it because it is vague and ambiguous and overly broad, right? I mean, come on. Harassment could mean anything depending on who you are and your political beliefs and your background. I mean, a reasonably objective person to someone in Berkeley is not going to be a reasonably objective person to someone who lives in Dallas, Texas, or Willis, Texas, right? Where people are walking around open carrying. So it's so vague. Oh, man. Anyways, so here, let me give you an example. In the city of Chicago versus Morales, it's a 1999 case. The Supreme Court invalidated a loitering ordinance is facially vague because it defined loitering as to remain in any one place with no apparent purpose, right? So that's vague, which neither clarified illegal conduct nor constrained police discretion, which violated due process. To me, that's very similar to what's going on with this harassment statute. Caveats. Facial challenges are tough. Courts prefer as applied rulings. unless the vagueness is egregious. Success often hinges on the statute's wording or the rights at stake. And in here, I mean, Lane's looking at like what, multiple years, like maybe 50, 60 years in prison over making a phone call and doing some YouTube videos. I mean, really? Come on, guys. Anyways, let's get into it now. So yes, in Arizona, criminal harassment is defined in the Arizona revised statute, ARS section 13-2921. And what it says is it involves knowingly or intentionally engaging in conduct that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, causes that reaction. So here, I'm going to drop this for you guys to read because this is what really got me about this case. I just am not buying it. Read that. Read that. I'm going to put it up on the screen. It involves knowingly or intentionally engaging in conduct that would cause a reasonable person to feel alarmed, annoyed, or harassed. And the conduct causes someone to have that reaction. Are you kidding me? You got to be joking me. How did this statute get passed into law? And how come the Supreme Court hasn't already overturned it? To me, this is a joke. This is not something that should ever have passed any kind. If I was a judge, sua sponte, I would dismiss the case and I would find in favor of Mr. Myers because anybody, look, little kids seriously annoy, alarm, and harass me all the time. And in fact, cause me to have that reaction. Young kids cause old people to have that reaction all the time. I'm seriously, I feel alarmed, annoyed, and harassed by people that I've worked for and clients. But that doesn't mean that I'm going to go to jail or they're going to go to jail for 20 or 30 years. It's ridiculous. To me, this statute is a joke. So anyways, give me a bunch of ones if you agree. That's what I wanted to show you guys is I think that I love this as a public service. I love all these other people who are out trying to fight for justice. But I want you guys to start thinking like a lawyer. The statute itself is absurd. And it should not even be law, in my opinion. All right. So let's get into it. So the ARS 13-2921 includes examples like following someone in public, repeated communications at odd hours. So there's case law that sort of validates what is and what isn't harassment, right? Or threats. Well, so far, I have not heard a single threat from anyone other than we're going to hold you accountable. All right. Now, if there was a clear and present threat that we're going to do bodily harm to you, we're going to kill you, that's different. But so far, nothing that I've heard from any of the preliminary hearings rises to the level of anything that would involve bodily harm. All right. Have you guys heard that? Put it in the comments if you have, because I have not heard anything like that. Now, odd hours, if you're doing it at midnight, but here's the problem, guys. This is a public servant and it's on a public phone. It's on a public email. So people aren't being threatened at night because she doesn't answer her work phone at night. She doesn't get paid to do that. So she might show up in the morning and hear a voicemail. Are you following me so far how absurd this is? This is a public servant. He literally showed her public servant phone number and her public servant email address. You following me? It's ridiculous. All right. So I would challenge it on its face under what's called the void for vagueness doctrine. And so what I'm going to do is I'm going to put this here for you guys to read. By the way, guys, my back's starting, well, my leg is all jacked up from sciatica, so I'm trying to get through this as quick as I can. So just bear with me, all right? So let's go ahead and take a look at this statute for potential facial challenges. This is what I would do in federal court. Like if someone was to pro hoc me in state court or as counsel, co-counsel for Lane in Arizona, in federal court, if we remove this case to federal court, which is a possibility actually, this is what I would argue. Okay, I would argue that It's unconstitutionally vague. The statute defines criminal harassment as a person commits harassment if, with intent to harass or with knowledge that the person is harassing another, they engage in conduct that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct does, in fact, seriously alarm, annoy, or harass. Well, to me, that's crazy. I mean, come on. And I'm going to put this for you guys to read again. And I will do that, Kevin E. Thank you, brother. Oh, well, Rob Mayfield asked, why was the anti-SLAPP, why didn't that anti-SLAPP motion do anything? Well, because if you read the actual statute, the judge has absolute discretion to grant or deny it. I don't even think there's an abuse of discretion standard. So it's like, come on, you really thought that that was going to get granted? I mean, I read some of it, and most of the arguments, in my opinion, as a lawyer, were conclusory. All right. And that was the issue I was trying to tell you. You've got to make fact-based arguments. Don't make a bunch of conclusory statements. And of course, if I was a judge, I would have given Lane deference. I would have said under Balistreri versus Pacifica Police Department that I understand you don't understand all the procedural guidelines and rules, and I would give you deference. But substantively, the judge doesn't have to do that. And probably a judge would rule that substantively, not making fact-based arguments in a motion would give him the right to not grant it. But in this case, I don't even believe there's a standard of review for these anti-SLAPP motions. So, obviously, if you have a pro-government judge, and I'm not saying that that's what happened here, but if you did, they could just throw it in the round file, So there was I knew the whole time it wasn't going to get granted. I've always told you guys from the very beginning, this case is going to be won on appeal. The only way that, in my opinion, he's going to win this thing at trial is if he has somebody like me going to trial, because I'm going to file so many pretrial motions, writ of habeas corpus, writ of prohibition, writ of mandate. I'm going to do everything that I can to knock out this charge before it even gets to a jury. So that's the difference. That's how I would handle this case. I'm not licensed to practice law in Arizona, so I'm kind of in a tough bind right now. And I'm also physically disabled. I'm a 70% disabled U.S. Marine. I can barely walk right now. I'm in so much pain right now that I'm dying. But I just want, look, my phone, I'm getting text messages here as I'm doing this show from people saying, talk about this, talk about that, about Lane this, Lane that. And it's like, look, I want to help this guy, so that's what I'm going to do. So just bear with me, okay? So the step one, here's what I would do. I would pinpoint the vague terms. I would say that the statute's language raises red flags for vagueness. I would argue that seriously alarmed, annoyed, or harassed is subjective. It's subjective. It lacks precise definitions. It does. What's serious annoyance to one person might be trivial to another. Give me a bunch of ones if you agree. What's serious and annoying to you might not matter to me. Like, I hung out with the Leathernecks Motorcycle Club last weekend. Those dudes cuss and swear and talk trash on each other. They might even want to have a fist fight with each other in 1 minute, and the next minute they're hugging each other. So what serious annoyance to them isn't the same as it is to you or me, right? But of course, I align more with those guys, to be honest. But you know what I mean? Like, I don't give a shit. Call me names. Call me at midnight. I don't give an F, man. Come at me and see what happens. That's where the inquiry begins with me. If you're brave enough to come at me, let's see what happens. As long as you don't make a clear and present threat to harm me or my family, I'm not going to the police. I'm going to handle it my own way. So if you have a loud neighbor, that might be trivial to one person. If you live in East LA where you got people playing rap music all night long and you're playing rap music super loud all night long, or what's the other music that those guys, banda music, right? And I know about East LA because my wife is from East LA. So I used to drive there to bring her Salvadorian food so I could win her over. She's like, what is this? How does this white boy know about Salvadorian food? Anyways, so harassed is circular. It's defined by the crime itself. All right. A reasonable person standard. Are you kidding me? A reasonable person, while it's often used in law, it's tied to vague outcomes. Alarm and annoyance? Are you freaking kidding me? What a joke. What a joke. Alarm and annoyance. Without clear boundaries, it's hard to predict what conduct crosses the line. Of course. Conduct? Conduct. Okay. The statute doesn't limit what conduct means beyond specific examples later on in the text. On its face, it could cover anything from speech to gestures to innocuous actions to a YouTube video. It could mean anything. So it's just crazy to me. So step 2, I would argue lack of notice. For a facial challenge, I would argue that the statute doesn't give people of ordinary intelligence clear notice of what's illegal. It could mean repeatedly texting a friend. Hi, that could be harassment, right? Just saying hi to someone. That's you could go to jail for 20 years for that. Are you kidding me? Because they find it annoying. Well, there's a lot of things about you guys that I find annoying. When I have people texting me at 2 a.m, texting me, asking me questions, when are you going to do another show about Lane? Or texting me saying, hey, you didn't make enough negative comments about Lane's lawyer, right? That means that you must be a member of the BAR, the British Accreditation Registry. That means that you don't support the people. It's like, that's annoying to me, but I'm not going to call the prosecutor and try to have you thrown in jail. And I'm not going to try to win over you. I'm going to try to win you over by explaining myself and sharing what I know about the law. And if you don't want to buy it, you don't have to. Call me names, call me a scumbag, send my landlord letters saying that I'm no good. Do what you got to do, man. Just stay away from my family because I will return fire. Okay. Now, it could compare the Coates case, Coates versus City of Cincinnati, 1971, where an ordinance banning annoying conduct was struck down because annoyance was too vague to guide the behavior, right? Clearly, having a YouTube channel and having people follow you and sharing a public website that has public servants' information on it should be protected by the First Amendment, okay? Whether or not he told people to call this public servant or not, I just don't see that meeting the threshold of a felony. What do you guys think? I just don't see that. I think there could be other ways civilly that this could have been dealt with, through the pocketbook, but not the power of incarceration. I just don't see that. You file a lawsuit, nuisance, invasion of privacy, even though it's not private because it's a public tax-funded university, but we'll get into that in a minute. Highlight the arbitrary enforcement. Okay, because we know that Lane is going after the system in a big way, right? We know that 99% of people probably wouldn't have the full force of the state coming down on him if he didn't piss off all these public servants who are all probably reasonably likely buddies with each other. Like, I know that police and prosecutors are usually buddies. Why? Because the police, okay, so imagine the law, okay, criminal law, it is a torch, okay? So I'm a cop. I carry a torch and I light it. It's called the torch of prosecutorial power. Are you following me so far? So I have this torch, I light it up, and then I hand this torch to the prosecutor, all right? It's called the torch of prosecutorial power. Are you following me? And then the prosecutor hands that to the judge. You go into a courtroom, the judge is going to have a bailiff or a sheriff deputy who protects him, as well as the court personnel, right? So even though the judge is a separate branch, he's the judicial branch, they're all collegial, they're colleagues, they're friends with one another. They play golf, they do go to, like I said before, Christmas, a lot of them go to Christmas parties. So there's going to be a bias, whether it's open and obvious or whether it's not. In my opinion, that you're going to have all these personnel are going to be somewhat biased towards one another. And so that's why I don't envy judges. And I think they have a hard job. If I was a judge, my staff would probably hate me because I would not make hard and fast rulings in favor of law enforcement and the prosecutors. Now, the other issue is that Most judges, I think statistically, were prosecutors. So there's also a bias there. So as a lawyer, and if Lane's going to be acting as his own lawyer, you need to understand that before you go and make all these arguments and start cutting people off mid-sentence and cussing at them, swearing at them, because that's not going to enamor yourself with them. And if your object is winning and not winning over people, then it's just something like civility is really, really important, guys. I can't impress upon you enough how important it is to be civil. And, I went to Calvary Christian School when I was a boy. And look, my parents sacrificed everything to send me to a good Christian school, and they weren't rich. And Pastor Fagerstrom, of course, Swedish, because we're Swedes. He said, at Calvary Christian School, we must be courteous, considerate, and kind to others. And even though I made fun of him back then, as I've become a full-grown adult, I really do believe that. And I think that that's how you should carry yourself as a human being. Be courteous, considerate, and kind to others. And obviously, if they want to mess with you, you got to do what you got to do. But, that's when the Marine comes out, right? But let me see. So Beer Break says that's why the prosecutor has a 56-minute video on how to delay court proceedings and screw over the defendant. Well, see, now Beer Break 1. I appreciate what you just said, but what you just said is a conclusory statement, and it assumes facts, not an evidence. So even though it might be true, if I was a judge or a juror or a prosecutor, or even a defense attorney, I'd be like, where's the evidence? So that's the issue that I have, is that you guys, if you want to start winning in court, you got to learn how to argue the evidence. You got to learn how to argue facts and not be conclusory. All right. That's just an example of a conclusory statement. So and I'm not putting you down, brother, because I know you're not a lawyer. I've been doing this for 20 years, dude. So I love you. To me, you're a brother. You're here, you're listening, and you want to learn. And so I got nothing against you, and don't take it as an insult, because it says in the Bible that we're supposed to be like iron sharpening iron. And that if a brother rebukes you, don't turn away and take it as an insult. If I'm rebuking some behavior that you're engaged in that's going to hurt you, and I know that it could potentially hurt you, don't look at me as your enemy, brother. I'm trying to help you, man. I'm just telling you how it is from my perspective. All right. I'm a pretty gung-ho dude, and I care about people. I wouldn't be doing these shows. Look, I spend more time doing these shows. I could be working right now, making a ton of money. That I'm doing these shows because I care about people, and my phone just keeps blowing up. And so I want to help people. I want to help people understand the law and be able to protect their families and their rights. And so don't take it as an insult. Don't take it like I'm trying to put you down. We all are different in our own ways, and we're all similar in our own ways. And the only thing that matters to me is that you believe in natural law. It says in the Declaration of Independence that our rights come from our Creator. As long as you believe in that, you're part of Team MPE, and I'm going to support you in any way that I can. And I know that guys like Reluctant Prophet, I know he doesn't agree with me on everything, but I love him as a brother, and I'll always be there to support him. I know guys like Mr. Gold probably don't agree with me on everything, but he's my brother, and I'm going to do what I can to help him. And the things that we disagree on, I don't care, because I believe in what's the doctrine of détente, DETENTE. That just because we don't agree with each other on everything doesn't mean that the things that we do agree on aren't important. And those are the things that I want you guys to think about. We should be forming parallel systems where we support one another, even if we don't agree with each other on everything. If you believe that your rights come from a creator and not from the state, then you should be following my channel, because that's the essence of what Team MPE is all about, that our rights come from a creator, not from some commie government public servant. And that if you really want to not get caught up in that system, you can form parallel systems. I mean, the Amish have done it. The Mormons have done it. You can homestead. You can homeschool. You can capture your own rainwater. You can have a family farm. You can do all that stuff, and we can all help one another and do that with each other, and not be part of some cult, like some Jim Jones cult, right? Just like our founding fathers wanted. Obviously, the first thing we need to do is get rid of the income tax and go back to a tariff-based system which is, how our country was until the banksters took over our economy and forced this Marxist income tax system on people. And then we saw Lois Lerner at the direction of the Obama administration going after their political enemies, using the income tax and the IRS to destroy people's lives. We don't need that. Why does the government have a right to know how much you earn? It's ridiculous. Obviously, it's done to control you, right? That's just an example. But let's get back in now to the statute itself. The full statute, ARS 13-2921, includes specific examples like following someone in public, repeated communications at odd hours, right? So we know that. Now, the statute raises red flags for vagueness. I mean, this whole seriously alarmed, annoyed, or harassed, that's crazy. I mean, these terms are so subjective. They lack precise definitions. What's serious annoyance to one person, again, is trivial to another. Reasonable person standard, while often used in law, it's tied to vague outcomes, alarm, and annoyance. Without clear boundaries, it's hard to predict what crosses the line. Conduct. The statute doesn't limit what conduct means beyond the specific examples later on in the text. On its face, it could cover anything from speech to gestures to innocuous action. I would also argue lack of fair notice. For a facial challenge, I would argue that a person of ordinary intelligence just doesn't understand it. The next thing I would want to get into is highlight the arbitrary enforcement, demonstrate that the statute invites inconsistent or discriminatory application. Police and prosecutors have wide discretion to decide what's seriously alarming or annoying. A loud protest might annoy you. Some, but not others. So it depends on who complains, doesn't it? It depends on who complains. That's the problem with this statute, guys. That's why I believe if he had a proper, constitutionally minded attorney, this dog does not hunt. So it has a tie to constitutional rights. You have to link vagueness to protected rights to boost your facial challenge. I would argue the First Amendment. The statute chills free speech. Public criticism, satire, or even persistent lobbying might annoy someone and trigger a prosecution, right? Might annoy a law professor, that's for sure. And again, NAACP versus Button talks about that. Vague laws impacting speech are supposed to get stricter scrutiny. I don't see that happening here. In fact, I haven't heard any of the judges even talk about the stricter scrutiny standard in this case. It's almost like it doesn't exist for Lane Meers. Due process. I'd argue without clear standards, the law violates fair notice and equal protection by enabling uneven enforcement. Okay. I would argue a facial challenge threshold. I would argue that the statute is vague in all its applications. I would argue United States versus Salerno. Here, I'm going to drop that link for you. I would argue United States versus Salerno. This is what I would argue if I was Lane Meers' lawyer and I was going to challenge this law constitutionally. I would say that even in clear cases like stalking, the core terms seriously alarmed and annoyed remain undefined, tainting the entire statute. Alternatively, I would argue that since First Amendment rights are at stake, like a YouTube video or telephoning someone on a public servant's telephone number or a public servant's email, that I would say it's vague in a substantial number of applications. And I would argue City of Chicago versus Morales. City of Chicago versus Morales, which is a 1999 case. And I'm going to drop that for you right here. Let me see here. Yeah, and I understand that, Randy. I got that. So Randy's saying that, just a correction, Lane's wife was fired within hours of a voicemail to Shannon Walker. And so that's really the gist of it. Lane's pissed because his wife worked for a federal judge, and she's very intelligent. I have that on good authority, okay? And basically, he had some kind of an altercation with Shannon Walker, and then all of a sudden, his wife gets fired from her job. And so obviously Lane would have to get evidence, probably have to take the deposition of the judge or the court administrative staff to prove that. But reasonable inferences can be drawn from the circumstantial evidence that Lane is likely, probably correct, that she did have or did set the process in force to get Lane's wife fired. And I think that's why Lane is so upset, because Lane's no dummy. And so if somebody got your wife fired from her job after you called her out and she was a public servant because you weren't happy with something her or her attorney husband was doing, and she was a law professor, and your wife got fired, what would you do? What would you do? What would a reasonable person do in that case, right? So anyways, legal strategy. If charged with if charged, I would file a motion to dismiss again. I would say, waving someone or calling someone is not harassment, and who cares if they're annoyed? Again, I would file a civil case seeking declaratory relief in either Arizona or federal court. I would want to show real world evidence that confusion, court records, inconsistent rulings under ARS 13-291. I would want to show other cases that got reversed on appeal, perhaps. And I haven't shepherdized the statute. And since I'm not an Arizona lawyer, I wouldn't even want to, because I don't want to get accused of practicing law in Arizona without a license, because that's not my intent here. I'm trying to show you the federal underpinnings of how I would challenge this in federal court, right? So counter arguments. The state would probably say that a reasonable person is defined in Grayned versus City of Rockford, 1972, which had to do with stalking in threads. And I would say those examples don't fix the vague core definition, which stands alone and could apply beyond them. Annoyed is a wild card. It is a wild card. Precedents to cite, again, Papa Christou versus City of Jacksonville, a vague vagrancy law that was struck down for lack of notice and enforcement discretion. FCC versus Fox television stations, a 2012 case. Vague regulations on indecent. Sounds the same to me. Here, I'm going to throw this out here for you. Vague regulations on indecent broadcast voided for chilling speech. I mean, if I was Lane's lawyer, this is the kind of stuff that I would be arguing. Here, check it out. I'll drop it in here for you. Are you guys following me so far? I hope you are. All right. I would check Arizona case law. ARS 13-291. Has it been upheld or narrowed in any cases? And I would obviously want to talk to a federal civil rights attorney who does criminal defense. Now, here's the next thing, because I hear a lot of people saying, especially it sounds like the prosecutor, that Shannon Walker is not a public servant or a state actor. So let's just clear that up really quick. Under civil rights law, a state actor is someone whose actions can be fairly attributed to the government, making them liable for constitutional violations. Private individuals or entities aren't typically state actors unless they act in concert with the state, right? So here, if she acted in her private capacity, or her husband acted in his private capacity to get charges filed by the county prosecutor against Lane, they would both be state actors and he could sue them for civil rights violations. But if her husband was acting in his official capacity, he would be acting as a state actor directly and possibly violating his oath of office, because he would be exceeding the scope of his office, right? Using his political power, political clout in violation of his oath of office to get a private citizen prosecuted. Let's face it, guys. Do you think that any other regular person could have gotten this kind of a result against someone unless they were a prosecutor themselves? I don't know. I want to know what you think. Okay, so the key question is whether the University of Arizona, UA, and its employees are part of the state apparatus, okay? The University of Arizona is a public university established and funded by the state of Arizona under the Arizona Constitution and governed by the Arizona Board of Regents, ARS 15-1621. It's not a private entity like Stanford. Courts consistently treat public universities as state actors when they perform governmental functions like education or discipline. So, for example, in NCAA versus Tarkanian, a 1988 case, the Supreme Court distinguished public universities from a non-state actor. All right. So employees as state actors. Employees of a public entity like UA are state actors when acting in their official capacity under color of state law, based upon the federal laws that I'm aware of. Okay, so without practicing law in Arizona, as a federal civil rights attorney, Ninth Circuit, I would argue that. You understand what I'm saying? Not, I'm arguing based upon a federal civil rights basis. And so they would be state actors. And I would argue under Title 42, Section 1983, that UA employers enforcing university policy, disciplining students or restricting speech, in this case, trying to restrict someone's YouTube videos, right? Trying to restrict someone's YouTube videos in my capacity as an employee of Arizona University, that would be a violation of Title 42, Section 1983 if I was Lane Meers. Because the authority and the appearance of authority derives from the state-funded institution. Are you following me? The appearance of authority derives from the state-funded institution. I would argue Hyatt versus State University of New York. And I'll drop that case for you to take a look. Hopefully you guys are having fun so far. Exceptions and nuances. If a UA employee acts purely as a private individual, off-duty, unrelated to their job, they're not a state actor. But here's the problem. The nexus of this entire case comes from Lane Meers contacting a public official at a public phone number that's on a public website that's tax-funded and a public tax-funded email. So I think that she would have a very difficult time arguing that she's doing this in her private capacity. It's all based on public. So that's just my opinion. I don't think there's a private capacity argument that would accept her from being sued in this particular case and losing. Now, campus police are definitely going to be state actors, right? But you could also argue joint action where she's collaborating with a university or, say, a prosecutor who she might be married to. So even if she was acting in her personal capacity, if she's evoking state action by getting her husband to forward charges to another prosecutor who he might be friends with, right? That's state action. You follow me? That could be state action. I mean, if I would never do. I just think that there's a whole can of worms here that's being opened here. And obviously, if Lane would have handled things differently, there would have been a different outcome. But that's not how it went down. And Lane's not a trained attorney. He's not me. He doesn't know this stuff. He just thinks, hey, man, these guys screwed my wife under and got her fired from her job. And I'm going to go after them as a public citizen by going after them in their official capacity to hold them accountable with public grievances, which are entitled to under the Constitution. So in his mind, he's just doing what the Constitution says he's allowed to do. Are you guys understanding me so far? Application of civil rights law. If a UA employee invokes state action, which looks like that's what happened here, to be honest, not only could she be liable, but the university could also be liable. And now they could invoke sovereign immunity under the 11th Amendment. And that could shield the institution from federal lawsuits unless waived. But I think that Title 42, Section 1983, under the U.S. v. Price state actor theory, would pierce that shield of immunity. All right. Now, Arizona courts have treated the UA in other cases as a state entity. Carlson versus Pima County, 1984. I'm going to drop this link for you. Under Carlson versus Pima County, a 1984 case that I found, it says absolutely. It's right there for you guys to read. It is a state actor. So, it's a state entity. Okay. It's not a private university, guys. All right. So if a dean was to suspend a student without a hearing, that's a due process violation. But if a UA employee insults you at a grocery store, that's not. Okay. Just to give you an example. All right. So yes, a UA employee can be a state actor. Now, Meers faces charges under ARS 13-2921. Arizona's harassment statute, allegedly for targeting Walker with YouTube videos and making phone calls, which I'm told he only made one call. So yes, that could potentially be prosecuted as perjury, but do you really think that these prosecutors are going to prosecute her for perjury, for lying under oath? Do you really think that's going to happen? Come on, guys. If you think that, I got a bridge I'm going to sell you. Now, the statute requires that, someone seriously alarm, annoy, or harass a reasonable person, and an actual reaction comes from the victim. Well, that all happened here, apparently. Now, there's stuff all over the internet, like on the This Is a Public Service channel, suggesting that Myers' videos criticized Walker, a public official, and included her public contact info. And ultimately, that led to a felony and misdemeanor harassment charges. And the case is State of Arizona versus, at least one of them. I'm going to drop it for you. State of Arizona versus Myers. I just dropped it for you guys to read. I'll put it up here for you. Hold on. By the way, guys, thanks for the super chats and buying memberships and stuff. It's really hard for me to do these shows when I've got a law practice to run and a family to feed. But this is just too good to not cover. And it's such interesting stuff that totally goes right in with what I'm all about, which is holding public servants accountable. Now, he's also reportedly under an injunction and facing additional charges for noncompliance with a trial that was set for March 28th, 2025, which I believe is today, in New Mexico in a related case or something like that. Myers argues that his actions are protected by the First Amendment. He claims that the prosecution is retaliating against him for criticizing a public employee. Whether Walker is a state actor could matter if Myers pivots to a civil rights defense, though his current criminal case hinges on the harassment statute, not a 1983 claim, right? That's why you got to pick your battle. He needs to set his case up to win based on vague and ambiguity of the statute, right? And then pivot into a civil rights lawsuit afterwards. That, in my opinion, that's how I would do it if I was an Arizona attorney. But I'm just arguing what I would do if I was in California or Texas, or if I was operating as a federal attorney, like a Ninth Circuit attorney in federal court that, was brought in pro hoc in Arizona. So now, Walker's status as a UA employee could make her a state actor if she's acting in her official role, but that doesn't shield her from harassment or make Myers' actions automatically lawful either. Okay, so public employees do have private rights, and courts do distinguish between targeting someone's official conduct and personal harassment that's not protected. So criticism of official conduct was upheld in New York Times versus Sullivan. Speech about a public official that gets robust First Amendment protection, even if it's offensive, unless it's knowingly false and defamatory with actual malice, right? But harassment, speech loses its protection if it becomes a true threat. And that's under Watts and Rowan. So I'm going to drop those two cases for you too, so you can see if what is going on here rises to that level. I don't think that it does. Now, challenging the statute or the prosecution, he should make a facial challenge, arguing that ARS 13-291 is unconstitutionally vague on its face when applied to speech about state actors, citing terms like seriously alarmed or annoyed. Again, Coates versus City of Cincinnati, 1971. Coates versus City of Cincinnati, 1971. And he'd need to show it chills protected expression in all cases. And that's a tough sell given the statute's specific examples like threats and stalking, okay? As applied is more likely a win for him. He could claim that it's vague as applied to his videos asserting their political speech, all right, about a public employee, not harassment. Success hinges on evidence. Did he criticize Walker's job, or did he target her personally in ways a so-called reasonable person would find alarming? Now, anti-SLAPP, he did file the anti-SLAPP under ARS 12-751, and that protects against prosecutions meant to silence speech, but the court just threw that out. So basically, that's, in a nutshell, the Lane Meers case. All right. I mean, that's That's what I would do to try and defend against Lane Meers if I was his lawyer and I was licensed to practice law in Arizona. So I can only like approach the case as if I was defending him in California or Texas. So I hope you guys understand. And I am in the process of trying to get waived into the Arizona bar, but the problem is I'm a disabled United States Marine. I can barely walk right now. I have serious sciatica, so it's been very, very tough for me. But I'm getting so many text messages and stuff from people asking me to cover Lane's story that I just decided I would do this for you. So what I'm going to do is I'm going to break this up and do a bunch of clips and try and do like shorts so you guys can learn a little bit about the law as far as constitutional challenges to criminal charges, in this case involving what I consider to be a very vague and ambiguous statute that leaves everything open to interpretation as to whether or not something's harassment or not and how it's applied in this particular case. So now I'm going to scroll up and try to see if I can answer questions. Oh my gosh, Rami. Now, Rami, Rami, I know I need to reach out to you, brother. I've just, as you know, I've been in a bad spot, but I will reach out to you, sir. Sassy kisses. Thanks, Sassy kisses. I appreciate that. Sassy kisses gave me a bunch of love and kisses. I appreciate that. Jody Shiloh, thanks for joining me tonight. So I just spent a couple hours with you guys, I think, just so you know, like this is a labor of love for me, but I do appreciate it when you guys give me a donation, even if it's just to buy a membership or even if it's $1.99, because, I am married and I got to justify spending all this time when I could be working on cases or taking my son to judo or Muay Thai. But I do feel that it's my duty to try and educate people. I know, I've tried to reach out to Lane before. I got no skin in the game. I don't even think the guy probably really likes me, to be honest. And that's fine with me because I'm not in this to try to win friends. I'm in this because I care about people and I feel that God has called me to try and help people understand their rights so they don't end up in jail. Chili de Castro, he's another guy. I did everything that I could to help him, and he's still a friend. He's a friend of mine now. We were acquaintances pretty much before, but visited him in jail and did everything that I could to help him with his channel. And ultimately, he got those criminal charges reversed on appeal. And unfortunately, people who are outspoken, who aren't part of the administrative state, the deep state, the bureaucratic state, the Democrat-run state, those people, like the Jan Sixers, will end up in jail. And the only chance they have is typically an appeal or a pardon. Unless you're in a jurisdiction that is a libertarian jurisdiction, like maybe in Texas, very, very difficult to win cases if you are a true patriotic American, in my opinion. So keep that in mind. And so that's why I try and teach people about their rights and teach them how to behave themselves in court, teach them how to be civil and courteous, considerate, and kind so they don't end up where Lane is. But at the same token, I'm not criticizing Lane because Lane's doing what he thinks is right in his mind. And I know that Lane probably is suffering from a lot of the outcomes of being abused by corrupt government officials and law enforcement, probably suffers from post-traumatic stress, and that it takes somebody who really cares about people to not only understand but respect that. I've had people with Tourette's around me, and I get it. I'm not saying he has Tourette's, but you know what I mean. Someone just constantly cusses and annoys people, and people get turned off by that. But you have to show compassion and respect towards people. You can't just discount people because they're not like you. Hey, what's going on, Clueless Beekeeping? Good seeing you, sir. Thank you, Grateful Dabs, for supporting my channel. I know I was going to show some of video and stuff of what was going on with Lane, but throughout the week I'll show some other stuff. But I just wanted to tell you guys what I would do. And thanks, Randy, for your corrections. And Brandy Swaney, good seeing you, ma'am. So happy that you made it tonight. Hey, what's going on? Delete laws. Super glad to see you, sir. Um, yeah, so we got Chili over here. He popped in earlier. That was nice to see him. Um, and then Jody Shiloh, John Locke. That's right, baby. Chili De Castro, John Locke. That's it, man. So all you guys, you guys all mean a lot to me. Over the last year or so, I've become friends with quite a few of you guys. Just want you to know that I apologize. I haven't been going live as much as I used to, but I have a bad my back and my sciatica is really bad, and like it's just been really depressing. So it's nice to get text messages and stuff from you guys asking me where I am. And then Rob Mayfield, I don't know about all of his other charges. I'm just talking about this particular case, and I know he's got a criminal history. I mean, who doesn't? Anybody who fights the system is going to get charged with something, right? So, and Kevin E, yeah, it's horrible. Yeah, but I do the horseradish thing. It's just not helping me like I wanted it to. American Nomad, good seeing you. um, and let me see here. Edward Potts, Canon 0311. Hoorah, brother, Semper Fi. Anyway, so with that being said, guys, make sure to like and subscribe. Make sure to save because we never know when the thought police are going to take down this channel. And always make sure to save as well, like save these videos for later viewing or listening. And, everybody say a prayer for Lane and make sure to donate money because I guarantee you that without his income, his wife is going to be suffering. I mean, after all, she did lose her job recently. So anybody who can provide financial support to the family, reach out to this as a public service and find a way to help him out. Do whatever you can. That's all you can do. And then just say a prayer and wish for the best, hope for the best, have faith. And hopefully, someday Lane will watch this video and take to heart some of the things I'm saying about just trying to be more civil. Don't cut people off, especially judges and stuff, because I think it'll go a long way towards helping you win your case. That's all I got to say. Guys, Semper Fi, do or die. God bless you guys. Talk to you soon.